Thanks for coming out to our season opener in Warburg. Tonight I'm going to talk about land rights. Do Alberta government agencies support law-abiding landowners or do they support law-abiding oil companies? I'm going to talk about a little bit about what happened in Armisie Field in urban Edmonton recently, lands that I manage and adjacent lands. This is where Mega Energy operates. Some of the facilities and wells are also licensed by Tidewater Midstream and Infrastructure. We'll refer to them as Tidewater. I just thought I would help people decide what they should do when the oil company refuses to pay on the land. There's two basic routes you can take. Both routes were taken here in the Armisie field, so I thought I would discuss the two routes and then do a bit of a case study of what actually happened on these two adjacent parcels of land in Edmonton. So this is primarily about a little company called Mega Energy Limited. I'm going to call them Mega. They were originally affiliated with a company called Tidewater Midstream and Infrastructure. They acquired Atchison oil field, which is just west of Edmonton, originally a Chevron field. They acquired it from Penn West. That included the Atchison gas plant, which is actually purchased by Tidewater. And they also purchased this little small field called Armisie Field in Edmonton that I'm going to focus on. More recently, in 2024, I believe, Maga took over some wells, including in this area, from Journey Energy, and that's sort of the extent of their operations and how they got to, operating the way they are today. So let's make one thing perfectly clear here. Mega Energy is just a dumpster. It's it's a place for larger oil companies like Penn West, like Journey, to dump their liabilities. Uh, they want to dump these liabilities, the larger companies, and then Mega will just go broke. Mega will, in turn, will dump those liabilities onto the landowner, onto you, onto the taxpayer, you and I, unless the orphan fund pays for those that cleanup. And because the orphan fund is underfunded, we don't really know what's going to happen in Alberta. Mega is now a total dumpster fire. Uh, its affiliate Tidewater closed that Atchison gas plant. Most of the wells, the oil wells in the Edmonton area that Mega produces or did previously produce can no longer be produced because there's nowhere to send the gas. You have to conserve this gas. You can't just waste it or burn it. Without a gas plant, they've had to shut in, and without being able to produce, they can't pay landowners. They can't pay their municipal taxes. As I said, they're just a serious dumpster fire. So, with talking on from the topic of fire, let's talk about don't get burned. Learn how to properly exercise your rights. And so there are five main rights that I want to stress that all landowners have. The first is before the oil company, when the oil company comes along in the first place. Probably too late for most people in this area, but you do have the right to refuse an offer to use your land for a surface rights activity. A surface rights activity is a well, a facility, a pipeline, or a power line primarily. So, however, if you do refuse to allow them access, that proponent of that activity can probably force their way onto the land. They certainly can if they have a license or a permit. That's called a right of entry order. I'm going to come to that in a minute. Um, the way to grant surface rights to an operator by consent is to either enter into a surface lease agreement, those are for wells and facilities, things that are on the surface, or a right-of-way agreement. A right-of-way agreement is for an underground pipeline or an overhead power line deemed to have a different set of rights because you can still use the land for some activities like agriculture. Um, doesn't matter how those rights are set out, whatever rights that are given to the operator, they can be terminated if the operator is in default, particularly of a written contract with a landowner called a surface lease. They can be terminated for default. You have the right to terminate that contract. You do not have to go to the former Surface Rights Board, called the Land and Property Rights Tribunal, and beg them to do it. You can do it yourself. That's one of the things we're going to concentrate on here tonight. You have number 4, this guaranteed right to be compensated annually for recurring and ongoing loss of use of the land and what's called adverse effect, and including by way of the government paying you in lieu of the operator. If that operator fails to pay you, that's under Section 36 of the Service Rights Act. Finally, the 5th right that you have is the right of reversion. This means that you have the right to have land that's being reclaimed, that's been restored to near its original capacity or its original use. You have the right for the use of that land that was being used by the operator to revert back to you once it's certified as reclaimed. So based on that, you can probably get paid even though the operator is not paying you until a reclamation certificate gets issued. So let's take a look at this background right of entry. I'm just going to go through really quickly the process here. So it starts out really with a license that's issued by the Alberta Energy Regulator if it's an upstream oil and gas activity, or by the Alberta Utilities Commission if it's a power line activity. That leads to an offer. This is often done backwards. It's supposed to lead to an offer, and that offer is the offer of a surface lease agreement or a right-of-way agreement. And there could be a license hearing prior to that offer. If you refuse that offer, then the license holder can go off and get this right of entry order, and there'll be a hearing and a compensation order, and then this will go down here. That's the right of entry order. Or you can accept the order and enter into the surface lease or right-of-way agreement, and that becomes your right of entry instrument. It's either a forced entry or an agreed to entry, depending on which process occurs here. Then you'll go in normally into the operations phase if the well or the pipeline actually is built or the well is actually successful. And then that's where the operator's got to abide by its contract. It's got to abide by the terms of that license and the terms of that right of entry order if there is one. And if the operator does not abide by any of those terms of that surface lease, well, then that's when you can potentially terminate the right of the operator. You can terminate their operating rights. Be careful not to terminate their rights to close in, etc. I'm going to come to that. Okay. Now you can do that if they default on payment or if they do any other default. So as long as they're in default of something in the contract, you can potentially terminate that contract. We'll come to that. So if that occurs, then we go over here to, there is a different scheme. They do have allowed rights under legislation to come on your land for cleanup, etc. That's under Section 101 of the Oil and Gas Conservation Act. We'll try to deal with that if we have time. And that's, that applies to the well or facility closure. So you can trigger closure of a well or a facility if that company is in default of their contract. So once the operations end, whether they end by you closing them or they just abide by the contract over time and the well it reaches the end of its useful life, or the facility, or in fact the pipeline, then closure occurs. A reclamation certificate gets issued, and then the right to use the area granted to the operator, that portion of your land that you've leased to them, that would return to you reclaimed. That's your right of reversion that we already spoke of. So that's the process, the life cycle process, and some different paths in that life cycle process that can take place depending on whether you want to consent or not, and whether or not that operator lives up to the terms and conditions of its contract or right of entry order. So there are two paths to remedy non-payment. So if the company doesn't pay, you can take the yellow path. That's what I call the slow government red tape path. You're probably going to take it for payment anyway, but in terms of termination, you can take a faster do-it-yourself path, which I've shown in blue on the bottom. So let's go through the yellow ones first. You can file a Section 36 application with the Land and Property Rights Tribunal that you have to prove to them that you were being paid an annual amount or some other periodic amount, and that you have to prove to them that the operator is no longer paying. So you have to show them what your last payment was and how much it was, perhaps give a copy of the lease contract or whatever binds them to keep making that payment to you. And if you can prove to the government that you are getting that payment, they will demand that payment from the operator. They'll say, you have 30 days to pay, and if you don't pay, we could terminate or suspend your right of entry. So either payment gets made, in which case that's the end of it, you get your money, or if payment's not paid, then the Land and Property Rights Tribunal needs to determine whether there's what's called a working interest participant in the well or the facility. That means sometimes more than one company share the ownership of either the mineral rights or the facility, and if there's more than one company, they will order the second company to pay. And if there is no working interest participant, then there will be a direction to pay order, and it'll be issued to either the working interest participant or the government if there is no working interest participant. And then payment will be made, certainly by the government in the worst case scenario. And then the Land and Property Rights Tribunal will have to decide whether or not it's going to suspend or terminate the right to use the site. In my experience, and the one we're going to talk about in Edmonton, they reserved the right to do that. They did not terminate or suspend the right to use the site. They also made a mistake, which we're going to come to. So now the other route, what I call the do-it-yourself route, it starts if you have a surface lease or a land or property rights compensation order. It's the same thing. If you need to find your default clause in your lease agreement, then that default clause will always say you got to give some sort of notice and you got to allow some certain period of time for that to be cured. We'll come to that in more detail in a minute. Either the payment gets made, and in which case everything ends again, or payment is not made, and then you can yourself terminate that right of entry with written notice. And either way, if the rights are terminated, then that's when the Alberta Energy Regulator needs to get involved, because under a certain section, 3.012A of the Oil and Gas Conservation Rules, when a surface lease terminates, the operator must, that's mandatory, must abandon, meaning decommission its well or its facility. It is not optional. Could be the best well in the world. They still have to plug it. So this is Section 101, Oil and Gas Conservation Act. This was amended in the year 2020. It says that right down here at the bottom right. And it's got 5 subsections. And the first one more or less says that it's different from this right of entry cycle that we've just talked about. So the operator does have guaranteed legislative rights to go on your land for certain things, and that is to provide reasonable care and measures, or to carry out a suspension, abandonment of a well, or remediation of land. That means clean up a spill or reclamation of land. So any of those things, the suspension, abandonment, remediation, or reclamation, you cannot deny entry for those purposes. If you do, you probably won't get your compensation. I'll come to that in a minute. So it says that, however, in order to enter for any of those things, abandonment, reclamation, etc., they've got to give notice to the landowner. And if you deny entry, they can go to the Court of King's Bench and enforce this law. So there's no point in denying this entry, and it could hurt you. So now, paragraphs 4 and 5 are important, and no one's ever done this. So it says a person who enters on any land to do these things, which is reclamation, remediation, abandonment, etc., shall compensate the landowner or the land occupant. If you rent some land and for farming and there's a well on it and they damage you as the rental person, well, then they have to compensate you. And this includes the Orphan Well Association. Okay, so they have to compensate you for any direct expenses or for any damage to your land, crop, or livestock arising from that entry. And then number five, if a dispute arises, to how much they should pay you, how much that person going in to close that well, clean up the well site, etc., is going to pay you, because they must compensate you. Subsection 4 says they must compensate you. Under subsection 5, if you can't resolve that dispute, well, the Land and Property Rights Tribunal resolves that dispute, and they set the amount of compensation for these unique entries. Okay, so but this does not include operations. So now we know that there's no such cases like this to date. So if the Orphan Well Association's operating on your land, or if they're about to, if you've got MAGA or somebody on there that's about to go bankrupt, you need to know about this, because you can claim compensation in the future if the Orphan Well Association's on their land, because they're not the lessee. They're not a party to the surface lease that you used to have, that used to govern the operations on your land. It's been terminated, or it doesn't apply to the Orphan Well Association at all. So this is all very important. So, in summary, do not deny entry for these things: to shut in a well, to suspend a well, for abandonment and decommissioning of wells or facilities, to remediate land that's affected by a spill, or to reclaim a site or a trespass area. So do not bar entry for those things. You can get, they have this entry under Section 101 of the Oil and Gas Conservation Act, which I just showed you. There's similar clauses in Section 28 of the Pipeline Act for pipeline right-of-ways. So this applies to pipeline right-of-ways as well, just under a slightly different law. So if the correct procedure is followed, first of all, you may terminate a surface lease for cause by reading and following the default and notice provisions in your contract, provided that you first give proper written notice to the lessee as required by your contract, and you also must allow them time, especially if there's a time set out in your contract. You've got to give them a reasonable amount of time to make payment, to cure their default, to build their fence, to do anything else that they might be in default in your contract. You may legally deny entry to the site for operational purposes only. And number 3, you may still apply to the Land and Property Rights Tribunal for recovery of the unpaid rate of annual compensation. Now, I suggest that you hire someone experienced to do this. If you can find a lawyer that's done this before, I think that's hard, or a representative. Certainly need someone who can interpret your contract, give the proper notices, make sure you spell out to that operator what you're allowing them to come on the land to do and what you're not allowing them to come on the land to do, so that you don't hurt your right to get paid. So that's what we'll talk about now under Section 36(8) of the Surface Rights Act. This the section reads as follows: the tribunal may direct the minister not to make any further payments due to the person if the tribunal considers that the person entitled to receive them is refusing access for operations, abandonment, or reclamation allowed by law. So in other words, if they're lawfully allowed to go in under Section 101 of the Oil and Gas Conservation Act, you should not try to block that entry. And if you do, they might stop paying you any amounts that are due to you until that reclamation certificate is issued. So just make sure you comply with Section 101 of the Oil and Gas Conservation Act and Section 28 of the Pipeline Act. So let's take a look at some default clauses in some surface leases. I can't cover them all, but a lot of leases are what they call Canadian Association of Petroleum Landman leases, so they have similar clauses. So this is the one you will see something like this most often in your surface lease, and it'll be entitled default. So it says, notwithstanding anything herein to contain to the contrary, or in spite of anything that might be contrary to this clause in the lease agreement, the lessee, that's the oil company, shall not be in default in the performance of its covenants or obligations under this lease, including payment of rental, unless or until the lessor, that's the landowner, has notified the operator of such default, and the lessee has failed to commence action to remedy the same within 30 days of the receipt of such notice. So, in other words, they can do anything, they can breach the agreement all day long until you give them notice. They're not in default till you tell them they're in default. And then once you tell them, you've got to say, you've got 30 days to cure that. And if they do cure it within 30 days, well, then the contract's still valid and you may not terminate it. But if you give them notice, proper notice, they don't cure the default, or they don't, in this case, start action to cure the default, well, then you can go ahead and terminate that lease. So here, the words commence action are very, very loose. That's very broad wording. So I don't know what commence action uh, is comprised of. That's not the greatest wording for landowners, but it is common wording. So if someone comes to you and they want to have a surface lease, a new one, don't agree to this clause. Just say something, you want something more forceful, like perhaps like the clause we're going to look at next. So then there will also be a clause in your contract that is you must give the notice in writing. So you've got to abide by that. And then perhaps if you mail that notice by registered mail, well, that could add 7 days to the 30 days. So you've got to look at both of these clauses, notice and default, together is the point I'm trying to make here. Now, I'm going to deal next with this specific default clause. We're going to discuss what happened in Armisie Field after I get through all this stuff. And this is the clause that I used to terminate a lease recently in Armisie Field in Edmonton, and I will read it out. So it says default, that if the lessee shall make default in the payment of any rental herein provided, and if such default continue for a period of 30 days after written demand, therefore shall have been made by the lessor and delivered to the lessor may re-enter upon the leased lands, whereupon this tenancy shall terminate. Now there's a typo. It says determine, and it should read terminate. And in my notice, I said, well, look, there's a typo, and that's what it means. That's my interpretation, etc. So that later they can't argue that the word determine was binding. Now, this clause is a little stronger from the point of view of the landowner, and you might find something like this in older leases, 1950, 1960 leases before they came out with the standard wording from the Association of Petroleum Landmen, like the previous clause we just looked at. Then let's take another one. This is really bad for the landowner, and it's the same as the first one we looked at, but there's some real weasel words that I've put in dark along the bottom here. And it says, so it's the same thing. You've got to give them written notice. You've got to give them time to cure the default. But it says a letter by the lessee of its intent to remedy a default shall constitute a commencement of action to remedy the said default. So in other words, they've just said, well, we can write a letter to you promising that we're going to cure this default. And if we do write that letter, we don't really have to do anything. That means we're in the process of curing the default, so you can't terminate that lease. So here you've got to be really careful. I haven't gone down this road yet. I would say that you would have to start giving additional notices and say, well, the letter's not going to cut the mustard. I'm giving you 30 more days or 15 more days, etc., to actually remedy the default before you try to terminate that lease. So for goodness sakes, don't sign leases like this when an operator comes to you. Really read these clauses and really think about them. I recently negotiated a contract, and the operator agreed to take out all this wording and more or less make it read similar to the one that I had from the older lease contracts, that if they don't pay within 30 days, you can terminate the lease. That's what you need. That's what it needs to say. So once you have terminated this right to be on your land, or once the Land and Property Rights Tribunal might have done so uh, because of non-payment or because of other defaults, then the question becomes, will the operator do what it's required to do by law, which I have on the right? And, you know, will the oil and gas regulator, the Alberta Energy Regulator, will it order that operator to do what it's required to do by law in the event the operator doesn't act according to the law? So when a surface lease is terminated, as I'm showing on the right, for any reason whatsoever, the licensee of the well or facility must abandon it. They must decommission it. That's section 3.0112A of the Oil and Gas Conservation Rules. Now, landowners can't plug these wells themselves. They can't shut in wells themselves. They're not allowed to touch a well or a pipeline, etc. So that's quite problematic. Most landowners wouldn't know what to do, shouldn't touch them anyway because they might do something that's unsafe, uh, cause a spill, cause an explosion, cause a pipeline break, who knows? So um, this is the problem. The issue here, will the regulator carry out its mandate? That is, that's up in the air. And that mandate would be the operator doesn't act to do the right thing, shut down, then abandon. Well, then the AR must issue stop orders, and the AR must issue abandonment orders. It doesn't have a choice at law. So it's like saying, will the police act if somebody robs a bank or commits a murder? Will the court act when they bring a murderer before the court? It's comparable to these things. Our regulator simply is not doing its job in many, many instances. And so will they do it here? That remains to be seen. So tonight's focus. You have these choices. There's the law, and under the law you have these choices, and you particularly have these choices when operators refuse to pay. And so I want landowners to know what actions they can take on their own. So I'm going to talk now a little bit about a case study, what happened in reality, how when you go to try to apply these principles in real life, what happens out there in the real world. So we're going to talk about Armisie Field in urban Edmonton, Tidewater and infrastructure. So we've got the one landowner that chose to make the government requests that I've spelled out, go through the Land and Property Rights Tribunal when there's non-payment. The other landowner, which I represent, chose self-termination of the surface lease. So we're going to go through what actually happened here. And what I can tell you is that Albertans, including landowners, we must somehow achieve a return to the rule of law because we've deviated so far from the rule of law in oil and gas, as this case study will show at Edmonton. We just can't seem to find our way back. So I could talk about the history of Armisie Field for a long time. There's a lot of things that went wrong. Um, but here we have this really old, complex problems. All of them got simplified when this operator failed to pay. All the complex reasons why they shouldn't be on the land that these government agencies can't seem to understand, they no longer matter. They're in breach of the contract for non-payment. That clause applied, and they were given the proper notice. I'll go through that, and that they did not pay up, so that triggered this mandatory obligation to abandon the wells or decommission the wells in the facility. And where we're at right now is, will the Alberta Energy Regulator enforce the law, or will they refuse jurisdiction for some reason and turn a blind eye to this problem, as they have in the past when they were asked to order abandonment here in the past for different reasons? So before I get into the nitty-gritties of Armisie Field, I just want to remind everyone that the Narwhal, which is a newspaper that came to two of our meetings last year, they did a story on this Meg Energy, focusing on Carl and other people in the area's problems with Meg Energy. And I would just like to remind everybody about that. Vitor Marciano came here. We all, people in the audience came down on him saying, why aren't you terminating these rights of these companies that aren't paying to go on the land? Why are you why is the province or to the regulators or the LPRT not terminating their right to be on the land, particularly when we as the taxpayer are paying landowners on their behalf? Why can they still operate? So let's talk about Armisie Field in Edmonton. It's in this area here. I've outlined certain lands in different colors for a reason. It is in southwest Edmonton. It's right on the riverbank. And we have two areas here, Windermere and Cameron Heights up here. And this is the general area of the city we're talking about. It's right on the riverbank. These lands are ripe for residential development. They're surrounded by residential development, new residential development encroaching here. It's time for this old decrepit oil field that's really not making any more oil and gas to give way for land development, residential land development. That's a much higher use. The landowners can realize much higher returns by selling or developing this land than they ever could for agriculture. So there are three landowners here, and people need to, until they appreciate who all the landowners are and the lay of the land, they can't really appreciate all the complexities here. So the land that I'm showing in green, which is a quarter section plus a little bit in the next section in a weird shape, those are lands that are now owned by the provincial crown, the province. And this is a special area. It's called the Edmonton Restricted Development Area, or a Transportation Utility Corridor. The Minister of Infrastructure is in charge here, or his delegate. There's people in charge of this transportation corridor. They've been notified about this over and over and over. They're unresponsive. MEG is not paying them either. They're trespassing on the Crown lands to get to private lands. I submit that the people that are in charge of provincial lands should not allow trespassing on those provincial lands, certainly not to reach private lands. And so things at Edmonton are very complicated. We have far more than one government agency here, and they're all unresponsive. That's why I've said, do government agencies in general favor illegal oil and gas over landowner rights? The blue lands here, those are the lands that I terminated the right of entry for, that by the do-it-yourself method that I've already discussed. So that's the blue lands. There's two well sites and part of a facility site within the blue lands. And then there are some private lands in pink, again, further to the south. And there is one, what's called a well pad there. It's a multi-well site, if you will. There's 5 active wells there, one abandoned well there. And so that's the landowner that chose to go the Land and Property Rights Tribunal method to recover their compensation and try to get the rights of the operator terminated. So just for interest, Armisie Field is an oil field discovered in 1951 in what's now southwest Edmonton, but it was formerly part of the Enoch Stony Plain Indian Reserve number 135. So this is the original area, the field that I've shown, the land we're looking at here in red, and this area is the second surrender. So there was the area up top was surrendered first and sold in 1902. I think there's still some dispute with the federal government over that, but the 1908 surrender, which is, Jasper Place and good portion of West Edmonton, including the current Armisie oilfield lands, they were the part of the 1908 sale and surrender of part of the Indian Reserve. So because of this, the mineral rights went with the land when it was surrendered and sold and back 2 centuries ago, and there was private minerals for most of Armisie oilfield. So in Armisie oilfield, we're not even getting public royalties here. The money that's, if MEG is paying those people, I highly doubt if they are, they could very well be producing oil and gas owned by freehold mineral owners and not paying them royalties. They're certainly not paying their taxes. They're certainly not paying the landowners. We don't know if they're paying those royalties to the private mineral holders or not. Somebody should determine that. So the owners here, Crown Lands in yellow, Braun lands in blue, Sing lands in pink, and the Braun lands are the ones where I've terminated the right of entry. And so the important thing here is that you've got to cross these Crown lands to get to the sites on the private lands, which are further to the south. So that's a key issue, and I just want to point out that access issue there. So let's talk a little bit about this transportation utility corridor, more properly called the Edmonton Restricted Development Area. The Minister of Infrastructure has prioritized jurisdiction over any other agency, including the Alberta Energy Regulator, who manages the or administers things like the tank battery, or over the Alberta Utilities Commission, who administers matters like the power lines here, or other government agencies that might look after the road, Alberta Transportation, etc. So this is the government's illustration of what activities take priority in the transportation utility corridor, and they call it a TUC. The TUC policy is that original uses such as the tank battery are to give way to primary uses. These lands in the corridor have been expropriated from landowners for these uses. The freeway, the power lines, the Trans Mountain pipeline runs through here in the corridor, etc. And it's these conflicting activities like the Armisie field tank battery that's half in the corridor, they're supposed to give way to primary uses. Now, it's really important that the Surface Rights Act is inapplicable in the transportation utility corridor by law, by the regulation that created the Edmonton Restricted Development Area. So this tank battery I've shown down here, the yellow parts in the transportation corridor, the blue parts on the private lands. Well, that may as well be the USA-Canada border. I don't know who decided to put that transportation utility corridor boundary right through the middle of that tank battery. And when the tank battery was established, there was two different property owners there. And so all of this was very poorly planned. Let's just say, to say the very least. Let's talk just a bit more about this transportation utility corridor, or the Edmonton Restricted Development Area. This is a view into the road on the Crown lands in the Restricted Development Area, looking towards the tank battery in the background. I've shown the red line. That's the Edmonton Restricted Development Area. South of it, where I've shown in blue, those are private lands. So we can see the battery in the distance, and there's a cell phone tower right adjacent to the tank battery. It's here. There's a incineration stack. That's where they're flaring right there. This is all on private lands. There's a pump jack here. There's more wells back behind over here, and there's more wells off to the right. So what do you think's illegal and unsafe here? There's a lot, actually. But the main thing that should jump out at anyone, it's plain for anyone to see, is there's a 500,000 volt power line owned by Altalink, and that power line overlaps the tank battery, which is not allowed by law. There's a minimum separation distance between a tank dike and this power line. Also, this cell phone tower here should not be that close to that incineration stack. So we have a lot of illegality here. We have a lot of reasons for shutting these operations down traditionally, let alone the new ones. So I just wanted to share that. Now, in the transportation utility corridor, which, as I said, the jurisdiction of the regulators is superseded by the jurisdiction of the Minister of Infrastructure if a decision of those regulators might result in a ground disturbance. So in this case, they have to abandon the south portion of the tank battery by law now because the right of entry has been terminated. That requires the written permission of the Minister of Infrastructure before the Alberta Energy Regulator could issue an order like that. So all this has been pointed out to the delegates, the people that are in charge of the transportation corridor, once I found out who the new people are, and pointed out to the operator, pointed out to the AR, but they're all are remaining silent. So the transportation utility corridor, because the lands have already been expropriated from the landowners, this is the only place in Alberta where oil and gas is not to be take top priority over anything else. But here in the Edmonton Restricted Development Area, that is ignored. Oil and gas is still taking priority here, even though that's against the law, even when that activity is illegal, even when that activity is unsafe, even when the operator is trespassing. The agencies of Alberta refuse to take action. What's wrong with that picture? I say everything. So this lease termination on the Braun et al. Lands, which I've shown outlined in blue here, it affects the operations of the entire Armisie oil field. There are oil wells at different locations. Here at LSD 13 of 33, there's oil wells and a disposal well here. At LSD 3 of 4, there's oil wells up here at LSD 7 of 4, and there's oil wells here at LSD 6 of 4. They all produce through these green pipelines. They produce oil well effluents, which is oil, gas, water, dissolved solids like salt in the water, etc. They produce those to the Armisie tank battery. Water and oil and gas are separated there. Gas is now flared illegally within the blue outline lands. That can't occur anymore because that's trespass as well. And the water is pumped back for disposal down here within Singland. So without the ability to use this tank battery, or at least the south portion of it, which is on private lands, the entire operations of Armisie Field extended, repercussions of this termination are that the entire operations must be shut down. I've explained that in detail to both well licensees and the facility licensee, both to Tidewater and to MEGA and to the Alberta Infrastructure Minister's delegates and to the Alberta Energy Regulator. No action. Let's talk about the actions taken at the Land and Property Rights Tribunal by the neighboring landowner. This is Singland, shown here outlined in pink so that no one gets lost. These are the actions taken by that landowner at the Land and Property Rights Tribunal. I did not initiate these actions. I simply looked at the published decisions of this tribunal. So in April of 2025, the landowner made application to the Land and Property Rights Tribunal. What occurred is the Land and Property Rights Tribunal issued an order for the Minister of Environment or the taxpayer, the taxpayers of Alberta, to pay the landowner on behalf of MEGA, who had not been paying this landowner for several years now. The decision to terminate or suspend the operator's right of entry was reserved by the Land and Property Rights Tribunal panel that made the decision. And in that paragraph 10 of the decision I've included here, and they talk about that the tribunal can suspend and terminate an operator's right to access the site. We went through that on the flow chart when appropriate. And then here, the problem is that the member of the Land and Property Rights Tribunal clearly looked at the wrong well license. And it said, based on the records from One Stop, that's the AR's software program, One Stop, the lease was suspended. Well, wells get suspended, leases don't get suspended. We've got these decision makers mixed up here. So it says that the decision to suspend was reserved. That's what's important here. So this is the copy of the first page of the decision. It says it's between MEGA and this landowner. And right here, what I've shown here is that the tribunal member has looked at well license 83960. Well, that's not the well license. I know all these well licenses in this field off by heart. I've represented this landowner on and off over the years, and immediately I noticed that this was the wrong well license. So if you look up the wrong well license, you're going to order the wrong party to pay. And if that party, MEGA in this case, doesn't pay, when here the tribunal should have directed Tidewater, who's the correct licensee of a different well license number, to pay. Tidewater probably would have paid. So this is what's gone wrong. Something's gone wrong with this decision, quite terribly wrong, actually. So Tidewater is the licensee, as I've said. They may have paid. If Tidewater would have paid, well, then you and I wouldn't have to pay this landowner for the continued illegal entries onto their land. And now they're crossing the neighboring lands illegally, plus the Crown lands. They're trespassing to get here on top of it all. So the key here is what's something called a working interest participant. I explained that in the flow chart. So Tidewater is a working interest participant here. The decisions is flawed because the Land and Property Rights Tribunal member looked up the wrong well license. The correct well license is 0003609, held by Tidewater. So let's take a look at the actions that were taken on the Braun et al. Lands. Those are the lands outlined in blue so that no one gets lost. This is the do-it-yourself termination. I did all this. And I also made related requests to the Alberta Energy Regulator and Alberta Infrastructure. So on January 21st, 2026, based on the default verbiage in the surface lease agreement that I've already gone through, I said to notice, paraphrase, take notice that you are in default of your payment obligations under the surface lease. You have 30 days to cure those payment defaults in full. And if you do not do so within 30 days, then the landowners might take any additional actions that they're entitled to take pursuant to the surface lease contract. And I gave background information, quite a lot of it. I copied the other landowners. I copied the private landowner. I copied the main information number for the transportation utility corridor, etc. And so everyone was advised what was going on, and MEGA did nothing. I heard nothing from MEGA. This notice was also given to Tidewater. I heard nothing from Tidewater. 30 days passed, whereby on February the 20th, 2026, I gave additional notice in writing. All these notices were given in writing. By the way, I delivered the first notice on January 21st personally to MEGA and Tidewater's offices in Calgary, so to avoid an additional 7 days' time. So on February 20th, 26, I gave written notice to both companies. I said you have not paid up. The surface lease to the Braun et al. Lands is hereby terminated for default. And then I demanded at that time, and I explained why, that the companies must shut in and must abandon their wells and the portion of the tank battery. I also pointed out that they shouldn't be flaring anymore within Braun et al. Lands, why that's been illegal for a long time. And I also produced, there's been some issue here, even Vitor Marciano that was here last year, he doubted that flaring was going on here, but they've been reporting flaring for years to what's called Petronex. So there's no question whatsoever that they're flaring illegally within Braun et al. Lands. So these companies must shut in their wells And the licensee, not necessarily the operator here, which is not necessarily the same thing, must abandon those wells under Section 3.012A of the Oil and Gas Conservation Rules, which I've already shown. So Mega has three wells at two locations within Bronatol lands. They were told that those must be abandoned. Tidewater is the licensee of the tank battery, and the south portion of it is on Bronatol lands. So they must abandon that facility by law. And they were all told that about this on February 20th. Now, Tidewater acknowledged receipt of this notice. Mega did not. Minister of Infrastructure was copied with all this, still no response. And the Alberta Energy Regulator was also copied for their information. And so a little bit of time passed. And a few days later, on February 26th, that should say February 26th, 2016, sorry about that. Sorry, February 26th, 2026, I went to the field. The wells and the tank battery were still operating. I entered on the lands, formerly took the land. That's, if you follow the verbiage of the surface lease, that's what it allows. It says you may re-enter upon the lands and the tenancy shall terminate. So the tenancy definitely terminated at this point in time. And I actually spoke to a person there that was operating the tank battery facility. They confirmed that there was flaring still going on. Then a week later or so, on March 6, 2026, I made a formal written application to the Alberta Energy Regulator because the wells were still operating. I had someone go out there and check, and I filed formal written applications with the Alberta Energy Regulator, requesting the regulator to do what it has no choice to do, and that is to order both companies to shut in, to cease this illegal flaring, and to abandon the wells and facility as appropriate, depending on who holds those licenses. So that very morning on March 6th, Tidewater phoned me, more or less said, "Wow, we're in dispute with Mega. We sympathize with you. We will do what the regulator orders us to do." That's a bit like saying, you know, I only drive the speed limit on highway number 2 if the court orders me to do so. It's a bit absurd. And the Alberta Energy Regulator has also remained silent. They have not acknowledged these formal relief requests, let alone acted on them, and MEGA has also remained silent. So what's next? Well, 2 days from now, today's March the 10th, 2026, on March the 12th at 11 a.m., we have called a press conference. We're going to invite the media on the land. I'm going to put up roadblocks and signs. These will be the type of roadblocks that will make a point. They can be removed if they want to go in for shutdown, if they want to go in for abandonment. Section 101 of the Oil and Gas Conservation Act provides that those companies give notice if they want to enter for those things. So they have to give me notice. And when they do give me notice, and they say what they're going in for, well, then we will allow them to move those roadblocks if it's for an activity that legislation allows them to enter the land for. But they're not going in for operational purposes. We're going to, go public because enough's enough. The people of the province of Alberta need to know if their regulators are acting legally or illegally, and they're clearly just not acting in the best interest of anyone here other than illegal operators. They're acting in the best interest of those who would operate illegally. That's not what regulators do. That's not justified by a regulator ever, not even once. So, and if all that doesn't work, well, the landowners won't have much choice. They'll have to go to court. They'll have to seek a writ of mandamus or an injunction or something to shut in, ordering the regulator and the operators here to shut in, compelling the regulator to do its job, etc. So all this is pretty complex stuff. the big issue here is when multiple agencies have overlapping jurisdiction, who is in charge? I've shown that we have these conflicting operations here. So we have all these different agencies and government agencies and regulators involved, and they're all passing the buck from one to the other. We have different regulators in charge of for example, the High Line that goes over top of the battery with two different regulators there. The Minister of Infrastructure is in charge. I went to the courts. I went to the Court of Appeal of Alberta to clarify when the Minister of Infrastructure, when his jurisdiction takes priority over the regulators. The Court of Appeal clarified that, and the Alberta Minister of Infrastructure still ignores what the courts have clarified. We've just we're just in lawless Alberta here. That's what's going on. We even have the Canadian energy regulator involved here to some degree with the Trans Mountain pipeline. It goes right through the corridor to the north of these lands. There are City of Edmonton jurisdiction involved here. There are safety codes. They're the ones that issue permits. They're the one that's permitted this cell phone tower to be too close to the tank battery, etc. So one thing about Armisie Field, if we sort these issues out here, who's in charge and what activities take priority over other activities, we could resolve, and what landowners can do, and what regulators are supposed to do when operators act illegally, who's supposed to pay for all this, who ultimately pays if the operator can't pay. All these matters could be resolved here across Alberta if we deal with them properly in Armisie Field. So I'm going to suggest that Armisie Field is the most important oil and gas location in the province. There's also numerous corporations involved. We've got the two oil companies here involved. There's the ATCO pipeline just north of the tank battery. That's a big natural gas pipeline. We've got the precious Trans Mountain expansion pipeline involved right there. We've got AltaLink Management. That's the owner of the power lines that overlap the tank battery. And we've got EPCOR Transmission and Distribution. You might have noticed that there's a substation shown in my satellite views throughout the presentation. That's a substation that's close to the tank battery. That's when I went to the Court of Appeal to have that moved a little bit further away from the tank battery because it was a potentially dangerous location. So we've all these different corporations involved. None of them will take responsibility for this illegality either. Someone's got to move either the tank battery had to move or the High Line had to move. Neither one of the operators will take responsibility. We just have irresponsible corporations and irresponsible government agencies in Alberta looking after these matters. We're paying them. We're paying these people's salaries. We need better decision making in Alberta. It's pathetic. So that brings me to the end of my presentation. I want to pose a couple questions to kick off our normal question and answer period and promote some discussion here. I want to carry on from last year. Vitor Marciano, Chief of Staff for Energy Minister Brian Jean, came here last year. The audience voiced their displeasure about companies like MEGA continuing to operate on our lands while the taxpayer is paying them. We all, I think that's just wrong. I think it is wrong. So the real questions here, I've posed two of them, and that is, are government agencies and the government itself, are they prioritizing the illegal activities of oil and gas companies over the legal activities of landowners? That might be agriculture, but in the case of Armisie Field, it's definitely the landowner's desire to either sell their land to a land developer or to develop the lands themselves if possible for residential use. But who's going to live next to sour gas flaring facility with a 500-volt power line overlapping it unsafely that could blow up? What if they did sell their land and someone ultimately purchased it to live there and found out that it was ultimately unsafe, or God forbid, it lost their life. Well, those are all important questions that we have to resolve in Alberta, not just leave them hanging out there. What's the proper compensation for these landowners? They're actually getting compensated less than the average person around Warburg, believe it or not, but their damages are incredibly higher. The second question is, when will landowners effectively become copycats? When will they copy the illegal actions of their government? When will they begin to emulate the illegal actions of oil companies? When will they say, hey, the regulator's not enforcing the law, I'm going to take matters into my own hands? Will they do that? Should I go shut down these operations? I'm qualified to do so. I know how to do so in Armisie Field, but will I be charged? Will the landowner get sent off to jail for trying to protect their rights? Or, you know, should we be shutting these oil companies down so that I don't have to contemplate doing something illegal to protect the rights that I have, or that my fellow landowners and clients in Armisie Field has? These are important questions. Let's discuss them, and let's kick off this 2026 season in Warburg, where we educate landowners more than anywhere else in the province. Let's start doing it, and let's keep doing it, and let's make sure these matters stay at the forefront. Thanks for coming out tonight. There's some news and events I'm going to announce for the Warburg Pembina Surface Rights Group, of which I'm a member. I'm not going to go through those. What I am going to go through is the location of the press conference Thursday, March 12th in Edmonton. Those of you who have mega wells on your land, you're invited. Come on out. Perhaps you might get a chance to speak to the media about delinquent operators, ineffective regulators, ineffective government decision makers, etc. And so we have the freeway here. You can take if you're coming from east to west, you can take the ramp on Cameron Heights overpass, get onto this Massacose Trail, turn left onto 184th Street. You're looking for River Heights Drive. At 15 River Heights Drive, I've cleared a path across the field through the snow. There's parking here just north of this pump jack. Just a little ways to the west of the tank battery, we're going to have a press conference in that location. This is how to get there. You're all invited. Let's see if we can't bring a little bit of attention to these matters and shake up this regulator to start doing its job. Thanks for watching.